Thank you, Maggie Orman from Orman Solicitors, for joining us on our podcast today.
Thanks very much for having me.
For our listeners and viewers, tell us a little bit about what you do and your experience.
I'm the director of Orman Solicitors and I've had my own practice for around 17 years. I specialise in property settlements, mainly family law, property settlements, and children's matters. So it's dividing the assets of parties once they're actually separated and also sorting out children's matters for parties. But I also do deal in wills and estates and estate matters if need be. And I have a background in farming, so I also do some farming matters as well.
We're going to talk about things that are related to property and family law. Explain what a binding financial agreement is and why it's important when you have a property asset.
A binding financial agreement is an agreement that parties can utilise in order to determine what would happen to their assets if in the event that they separated down the track. So if in the event that partners decided that they were going to go into a relationship and they both came in with assets from their own sides, what they can do is put that down on paper and document it with evidence in order to say that this is what they had at the beginning of a relationship. And then if in the event that they separate, this is how it's going to be divided. So they're a really good tool in order to protect assets that you've brought into a relationship, an initial contribution.
So basically, from when you start the relationship, is there validity to them from the assets you build together?
Yes, definitely. So a binding financial agreement can take into account anything that you've done together as well. So, for example, a couple might get together and they might be together for a period of 20 years. And initially, they might have both brought in some assets, but the binding financial agreement can take into account what should happen down the track if they separate in 20 years' time. They can also look at whether you have children, whether you have inheritances. They can take into account all sorts of factors.
Could you reassess your binding financial agreement as you go along in the relationship?
You definitely can.
What's defined as a relationship?
Parties living together, parties having children together, parties having a financial relationship together. It's and if they're actually in a true and proper relationship, which is a relationship generally between man and woman, but a relationship can also be same-sex couples, and if they're making contributions towards each other and supporting each other.
So situationships don't count.
No.
Maybe not. I don't think so. Okay, so what should a binding financial agreement cover?
Well, it should cover, it's trying to cover everything into the future, which is very hard to predict what's going to happen in the future because we don't have a crystal ball. So you might get together and you might have a beautiful relationship, until you both pass away. But the statistics show that not all of us are that lucky these days. We're not seeing those big relationships that we've seen in the past, the 40, 50, 60-year marriages. It's very rare that we're seeing those these days. The family court at the moment are taking into account as a long marriage, it's 9, 10, 11 years. So once they're getting up into double digits, they're being taken into account as a long relationship. But a binding financial agreement is trying to say this is what will happen if in the event that we separate.
This can be quite uncomfortable for many people in a relationship, and the uncomfortability is, if that's even a word, sorry, is how do you bring it up to your partner? Do you have any tips on your end?
Definitely. I think that you would want to bring it up in the beginning because at the beginning of a relationship, what we call the honeymoon, it's often everything's very nice and you're quite timid to bring it up. But I think if you don't bring it up, it could well turn out to bite you in the long run. So if you're coming in with an asset, I think it's fair and just in order to say to somebody, we're in a relationship, I'm wanting to go further, but I've brought in a house, for example, and I've got $500,000 worth of equity in that. If in the event that our relationship fails, then I want to be able to protect that equity and I want to be able to leave with that equity. So I think you've just got to rip the Band-Aid off and you've just got to say it. And if in the event that the other party is quite negative towards that, I think that that's telling you something about the relationship and you may question whether you want to be in that or not.
Do you have sort of any statistical data around how many marriages tend to last There's not now?
The statistics keep coming up around the 50%, but there's a lot of other relationships. A lot of people don't get married these days. A lot of people are in relationships and simply choose not to marry. So it depends on what sort of relationship that you're looking at. There's all different sorts of statistics.
From a lawyer's perspective, and this is not in these questions and you don't have to answer, what are the kind of questions you think everyone should be asking their partner before they decide to enter into marriage or a binding financial agreement?
Well, I think that they should be asking, what are your assets? What are your liabilities? What's your superannuation? You'd like to know exactly what you're getting into, because in a marriage, it's for better, for worse, for richer, for poorer. So you might take somebody on board and you might not realise that they've got $200,000 worth of debt. So suddenly you're involved in that debt. So I think it's really good to have a clear picture of the assets, the liabilities, and the superannuation right at the beginning of the relationship. And it's really good to have evidence of all of that, because if it does go pear-shaped or turns bad in 10 years' time, you've got all of that evidence and you can provide that.
So going back to how to bring it up to your partner. So you've brought it up to your partner.
Yep.
You've started talking about what should be in the agreement.
Yes.
However, what happens, and if you have any tips, what if they're resistant to those terms?
I think if they're resistant, you probably need to broach it again and say, look, I spoke about this a while ago and you haven't come back to me. We really do need to look at this because it's really important to me. So I think you've just got to emphasise that it's really important to you, and you want to make sure that the asset that you've worked long and hard for is going to be protected. And if in the event that they don't want to discuss it, I think you've really got to reevaluate, because that's telling you something about the other person that you probably didn't know. And most people, I have a lot of couples that are wanting to enter into binding financial agreements, and generally most people are fine with it. They'll say, okay, well, if you've come in with $500,000, yes, that's a large contribution from your side, and that should be protected because you've worked long and hard for it. So most people are pretty sensible about it. So if they're not, it's telling you something, and you've got to reevaluate.
When should you have one done?
At the beginning of a relationship. You can certainly have one done during a relationship, but I definitely think at the beginning, because it's really setting the tone.
So what can happen if you don't have one?
Well, the Family Law Act certainly takes care of you to a certain extent, but sometimes couples are coming in and seeing me and they might have got together 40 years ago, and it's very difficult to have evidence from way back then. And all along the period of the relationship, it's still difficult to have a lot of that evidence. So if everything is put together in the event that at the beginning of the relationship, it's a much better idea than trying to work it out 40 years later and I'm trying to piece things together for them.
You mentioned statistically that there are 50% of marriages that end up in divorces, and obviously no one's going to be single forever, not all of them. And then they get into another relationship and then they bring in their own children from their last marriage and it starts to blend. So why is a BFA so crucial to protect everyone in a blended family environment?
I give a lot of advice to couples in second and third marriages, because these days, as I said before, we're not seeing those really long relationships and we're often having 2 and 3 relationships. And I'm often saying third time lucky. So it's really good to have a BFA then, because you might have had somebody that's already worked for 30 years before they're getting into this second or third relationship. So their assets that need to be protected are quite large. Their superannuation will be quite large because they've had quite a big working life already. And then it's got to be taken into account of what the other person's bringing in as well. But then we've got children to look after too. And we've got children coming in from both sides. So this is where both of them need to get the proper estate advice as well, if in the event that anything happens to either one of them. So family law and estate sort of cross over slightly as well, because you're wanting to take care of everyone if in the event that the relationship breaks down with a binding financial agreement, but you're also wanting to look after everyone's children and either the husband or the wife, or in a same-sex relationship if in the event that either party dies.
Why do you think that 1 in 2 marriages end in divorce these days?
Why? I believe that years ago there weren't the services available, especially to women, that there are now. And I believe that religion played a large part in it as well. But a lot of women weren't working and basically had to stay. And these days, I do think that both men and women are less tolerant.
Everyone loves a story, everyone loves a case study. Anything that you can share with our listeners?
There's a matter that I had quite a few years ago, and they didn't actually, at the end of a relationship, they didn't get everything written up properly. They decided to do stat decs on their own, and they thought that they'd had a property settlement, and they thought that they'd done everything properly, and of course they hadn't, because at the end of a relationship you should actually enter into consent orders where everything is signed off, everything is agreed upon, and then the court actually stamps it. And in this case, they didn't. And we had one of the parties come back about 15 years later, and property had risen substantially. And what happened is that that person then had a property settlement 15 years later when the property had risen substantially. So it was that mistake in entering into the statutory declarations rather than consent orders cost them millions.
So whose fault would that have been? Would it have been
Both of them. They really both should have entered into it. And they should have got proper advice at the time. They didn't get advice and they thought that they could do it themselves.
a lot of people, not only because it's an uncomfortable conversation to have and everyone just believes that, romance is not dead and that they're going to stay with their partner forever, but they're expensive, BFAs, aren't they?
BFAs can be expensive. And because you might go to somebody in order to do a BFA and that might be done quite cheaply and quite quickly, that is not the BFA that I think that you should be entering into. In order to enter into a proper BFA, it's probably going to cost upwards of $5,000, I would imagine, but it should be done properly. All the evidence should be there. It should be negotiated between the parties, and the solicitor would be trying to look into the future in order to cover everything, in order to look at inheritances, children, different wage amounts, people may be receiving a workers' compensation payment. They're trying to predict everything that they possibly can into the future, which is a hard job. But there's quite a bit to it. It's not a simple process at all, and it's got to be done well, got to be done properly, and you need the evidence as well.
So, is a BFA a set and forget? If it isn't, how often should you be reviewing this document?
It's really up to the parties involved. It can be a set and forget, but some parties may say, oh, we entered into a BFA 10 years ago, maybe we should relook at that just in case something does happen. You could treat a BFA like your will. It should be reviewed every 5 years or so, or when you have a large event. So, for example, you should be relooking at things when there's a marriage that takes place, when children are born, when there's a life-changing event. So you can review the BFA as well. A lot of people don't, and they just do it once, and I suppose that's their relationship insurance.
Moving on to the fun part of this podcast, let's talk about wills.
Okay.
Isn't it important to have a will if you don't have any assets yet?
Yes. Yes, I think it's vitally important for everyone to have a will from 18 onwards.
Right. What would you put into that will?
Well, for example, at 18 you might not have much, but that will could still be in existence when you're 55, for example, and that could still cover what you want to happen. So, for example, at the age of 18, you might have a car, you might not have a car, and you might have a bit of superannuation. You might have a few chattels, but and you might leave all of that to your parents. But as time goes on and time moves quickly, you're going to build up assets, and often they build up quite quickly. So that's why I think you should have a will from the very beginning, because if something does happen to you when you're younger and you don't have a will, then it's more complicated in order to deal with your assets. And so I had a matter a while ago, and there was no will, and this particular person was killed and was quite young. And we then had to apply for letters of administration through the Supreme Court. It makes it more complicated and more costly.
What happens if you don't have a will, you don't have any dependents, and you don't have any known immediate family? Where does your assets?
It would go through the line of succession. So we would have to look at who the relatives are, and then we would work through that. But generally in your will, generally that's where you're going to be stating who everything should go to.
How often should you revisit your will?
Well, I think every 5 years or so, and especially when there's a life-changing event, like if you get married, you should definitely relook at your wills. If you partner with someone and decide to move in with someone, look at your wills. If you have children, if you become retired, if you become redundant, all sorts of life-changing events, it's good to relook at it just to make sure that it's correct. You might have had a partner pass away, so therefore your estate that you were going to leave to your partner, the partner's no longer alive, so now you've got to leave it to somebody else.
I suppose you've touched on this, but what could go wrong if you don't have a will?
Well, your assets could potentially end up in a way that you don't want them to end up. So a will gives you control in order to say where your assets should go that you've worked long and hard for. For example, if you died at age 70 and you'd worked all of your life and you didn't have a will and you had 3 children that have looked after you and been really good to you, then they would have to then go through a court process in order to apply for letters of administration, and it would make it more complicated. I'm not saying that it wouldn't work out correctly in the end, but it would be so much simpler if you entered into a simple will at the beginning. And a lot of people don't, and it just makes everyone's lives more difficult.
How long does it take to prepare a will?
I can take instructions in about sometimes 15 minutes, 30 minutes, and then we can just have them drafted up very quickly. But in relation to a will, I also suggest that you have a power of attorney and an enduring guardianship. So I say that they all go hand in hand and they can cover you for the rest of your life. So if you have a will and once you pass away, who you're going to leave your assets to, and then if you have a power of attorney, so if in the event that you have dementia or Alzheimer's, for example, at an early age, then that person, your power of attorney, can actually look after your financial affairs whilst you're still alive. And then I also recommend that you have an enduring guardianship, and that gives your guardian the power in order to look after your health and lifestyle decisions. So, for example, if you're in a coma or a vegetative state, they have the power in order to turn the switch off. And they also are able to look after your nursing home and any medical and dental needs that you would need.
What if you want to have those things, but you don't have anyone that you can lean on? Is it a service you can pay for?
If in the event that you don't have anyone, we normally have some pretty frank conversations in order to work out who can do what. And if in the event that they simply don't have anyone, then I work out who the next best possible person would be.
Borrowing money from the bank of mum and dad to buy a property. Why you should document the loan or gift in a legally binding agreement.
So if you have a couple that have received, say, from the wife's side, $1 million in order to purchase a home, and that's at the beginning of a relationship, and then 15 years down the track, the parties decide to separate, that $1 million should be accounted for because it's a gift that's come in from the wife's side of the aisle. So that's got to be accounted for in any relationship and in any relationship breakdown, that it's a gift from the wife's side. So it's got to be taken into account, and it should be documented so that the property settlement is done the correct way.
So does that form part of a BFA?
It can form part of a BFA, but it can also just be in the mix of things once it happens, because you might enter into a BFA at the beginning of a relationship and then the $1 million is gifted throughout the relationship.
So when you say it's a legally binding document, is it something that's drafted up by, say, yourself, and then all parties sign
We
off?
would have a loan document done up. So, for example, if the wife's parents gave her $1 million, we would have that drawn up and we would look at interest rates and we would also look at repayments on that so that it's done properly and it is an actual loan. But if it's a gift, it's a gift. But we would also have that documented. So if in the event that the relationship did turn sour, we've got it all documented there and we know what was given and when it was given.
Does this happen before you buy a property or after you buy a property?
It can happen
to
at
any effect?
any time.
Yeah.
So, for example, you might have couples that have been together for 25 years, and suddenly one of their parents says, from the husband's side, I'm going to give you $2 million in order to go and purchase a farm together. And that should be documented and all put on paper, and all parties should be signing it and looking at loan repayments and interest rates.
Mm. All these things we have to look at sort of makes relationships less romantic.
It does, but I think it makes parties feel more secure, especially in parents gifting money. I think that it would make parents feel much more secure if they knew that there were a loan agreement. If in the event something did turn sour, it would make them feel comfortable. And also the party receiving it too, because I don't think that they'd like to see their parents' hard-earned money be squandered.
Do you provide advice? So, for example, if let's say I was gifted $1 million by mum and dad, thanks, mum and dad, and and I came to you and I said I've been gifted this money, would you then discuss the different options around whether it was to be structured as a loan agreement versus a gift?
Definitely. If you were in a relationship with someone and this $1 million were going towards the purchase of something that you were purchasing jointly, then I would be giving you some recommendations.
What to do if your child is in a relationship and you are gifting money?
I think you'd want to think about it long and hard before you gift any money. I'd be looking at the length of the relationship. I'd also be looking at my child and also their partner. I think you'd have to take that into account, how sensible they are with money. Are they going to squander it? Are they hopeless with money? I think you'd take that into account, but you definitely want to document it and make sure that it's done properly. So if in the event that something were to happen, your loan is recognised.
Just coming back to sort of the family court side of things, because I've heard case studies where family court matters can go on for years and years and years and years and years, and it's just like, when does it stop, and what can you do to protect yourself as much as you can right from the very beginning? Because even
Whilst you're in a court matter.
yeah,
Yeah, so if in the event that you can't reach an agreement with the other side and you need to go to court, I would suggest that you put on very sensible offers in the beginning in order to try and protect yourself from costs. So what you would do is look at it really commercially, I suppose, in order to say, rather than have court costs going on for years, what am I prepared to walk away with? What am I prepared to settle this on? Because no one wants court costs and no one wants a matter dragging on for years and years. The majority of matters are settled. We only see a very small proportion of matters that end up before the court, and then an even smaller percentage of matters that actually end up before the court in a final hearing. It's a tiny percentage. A lot of people just get it sorted out.
at what point do they get to final hearing? Like,
That's years down the track. Once you actually commence before the court, it could take a minimum of 1.5 years in order to get to a final hearing. But the courts of great assistance to everyone. They offer mediations, they offer conciliation conferences. Judges, registrars are continually looking at matters in order to try and help solve them. The court want matters out of their court. They want matters settled. So that's what good practitioners, good solicitors and barristers, they're there to settle matters and to do it properly, but to do it in a time and cost-effective manner.
what if you have one party that's just unresponsive?
Sometimes we have that. Someone just won't respond and they've put their head in the sand and they just don't want to know about it. And often in those matters, we might have to find them first of all, and then we'll have to serve them with court documents, and then we'll have to bring them before the court, and it has to be dealt with, because every party is entitled to a property settlement. No one should be able to retain another person's property. Everyone should be able to have a property settlement and move on with their life.
Please always seek independent legal advice in relation to your matter. Full disclaimer.
That's right.
I think what you do is just so vital, especially in the modern world of marriages and dating. And yeah, there's a lot of, well, what you don't know. And I think everyone is hopeful and that things can go south, and you just want to protect yourself and mitigate the risk as much as you can.
Yeah, I think it's really relationship insurance. And I've spoken about this before, that we take out insurance for everything: home insurance, contents insurance, car insurance. And really, I think we should be looking at relationship insurance. And it can just be a one-off, as Kelly was talking about at the beginning of a relationship, and it's a one-off cost which can really help you in the future if in the event that it goes wrong. So it's not even an annual fee that you're going to pay. It can be a one-off at the beginning.
But maybe it should be an annual fee or a subscription that you insure your relationship. I mean, didn't you hear, I don't know if we should put this in the podcast, but didn't Mariah Carey sue James Packer for wasting her time? Like,
Remember that?
Yeah. And she won. Because he was like wasted a year of her time or something on the relationship, and she poured millions into like the relationship, and so the court actually were like, yep, he wasted your time.
You can sue anyone for anything.
But yeah, it would be nice to be able to do that, but I haven't seen it happen. But I believe that Mariah Carey did keep the enormous diamond ring.
Oh, did
I
she?
think that was worth quite a bit of money.
There you go. Thank you, Maggie. I hope that one day, if we ever get married, that we'll never have to see you because of a divorce. But I think
Yes.
it's so crucial to get a BFA and discuss it with your partner, but also, getting the wills planned as well, especially when you have an asset to protect you and
Definitely.
everyone else.
That's right. And especially in the case of a blended family.
Mm.
Thank you.
Thank you so much.